This is the second attempt. Once you've heard this, tell that liar to shut his mouth, because he's an enemy to Native people everywhere, sabotaging the best chance we have at Landback. The state of Oklahoma has maintained unlawful possession of Cherokee tribal lands for over a century in direct violation of federal statutes and treaties. Plaintiff, representing the Western Cherokee people of Oklahoma as a whole, is both a member of the Western Cherokee people and is duly enrolled in the Cherokee Nation of Oklahoma and united to a band of Cherokee Indians in Oklahoma, brings forth this action to establish the Cherokee people's rightful ownership and control over these lands, as well as to recover compensatory damages for the state's deprivation of tax and natural resource revenues during its unlawful occupation. Plaintiff submits the following in support of these claims. Arguments and authorities. Title 25, Section 180. Enacted by Congress June 30th, 1834, this statute states every person who makes a settlement on any lands belonging to, secured, or granted by treaty with the United States to any Indian tribe or surveys or attempts to survey such lands or designate any of the boundaries by marking trees or otherwise is liable to a penalty of $1,000. The President may, moreover, take such measures and employ such military force as he may judge necessary to remove any such person from the lands. Title 25, Section 71. Enacted by Congress March 3, 1871, this statute states no Indian nation or tribe within the territory of the United States shall be acknowledged or recognized as an independent nation, tribe, or power with whom the United States may contract by treaty. But no obligation of any treaty lawfully made and ratified with any such Indian nation or tribe prior to March 3, 1871 shall hereby be invalidated or impaired. Treaty of 1833 between the United States and the Western Cherokee. The treaty solemnly pledged a guarantee of 7 million acres in the northeast corner of the present-day state of Oklahoma to the Western Cherokee people. The current boundaries of the Cherokee tribal lands encompass a 14-county area within the borders of the state of Oklahoma and include all of Adair, Cherokee, Craig, Nowata, Sequoia, and Washington counties, and portions of Delaware, Mays, McIntosh, Muskogee, Ottawa, Rogers, Tulsa, and Wagner counties. These lands were promised to the Cherokee, quote, forever. The Treaty of New Eshota, 1835. The treaty reaffirmed the 7 million acres in the present-day Oklahoma in exchange for the complete cessation of all remaining tribal lands east of the Mississippi River. Additionally, the treaty further promised the Cherokee people these lands would be theirs and their children's without the territorial limits of the state sovereignties, and would furthermore possess the freedom to create a system of government consistent with their values and beliefs of the Cherokee people and their cultural identity. Solomon v. Bartlett, 1984. U.S. Supreme Court discussed the use of allotment to disestablish tribal lands. It was the opinion of the court that allotment was insufficient to disestablish tribal lands. The court further stated that only Congress, through a clear declaration of intent to disestablish, held the power to disestablish tribal lands. To date, no such declaration has been made, and the status of the tribal lands in regards to criminal law in Oklahoma was confirmed in McGirt v. Oklahoma, 2020, while the status of the Cherokee tribal lands specifically was confirmed in Hogner v. State, Oklahoma Criminal Appellate, 2021. Hooper versus the City of Tulsa, 10th Circuit, 2023. The 10th Circuit discussed the jurisdiction of municipalities on tribal lands. It was the opinion of the court that the municipalities in Oklahoma lacked the jurisdiction over tribal citizens on tribal lands. This finding of the court, which, like the opinion of the U.S. Supreme Court decision in McGirt, Oklahoma, supports the fact Congress granted exclusivity to the tribal governments over tribal citizens on tribal lands. Worcester v. Georgia, 1832. U.S. Supreme Court discussed states' rights on tribal lands. It was the opinion of the court that the Indian nations were distinct political communities having territorial boundaries within which their authority is exclusive. This opinion of the court held that the Constitution granted exclusivity to the tribal governments over the legal affairs of tribal citizens on tribal lands with federal oversight. This would apply to legal matters of both a civil or criminal nature, whereas one or more parties is an enrolled member of a federally recognized tribe. U.S. Public Law 280, 1953, if enacted, grants states the rights to the legal affairs of tribal citizens. Oklahoma's failure to enact PL 280 could indicate an informal policy of non-interference held by the state. The fact that this would ease the burden of cost on the state's legal system would support such a conclusion. United States versus Lexington Mill Company, 1914. U.S. Supreme Court discussed statutory construction. The court stated, where such a purpose has been affected by plain and unambiguous language by an act within the power of Congress, the only duty of the courts is to give the act effect according to its terms. This would support the plaintiff's interpretation of the statutes and treaties in question and compel the conclusion that the Cherokee tribal lands have been unlawfully occupied. Conclusion. In closing, we can see many facts which appear to be self-evident. First, given the clear and precise language of Title 25, Section 180, we can see that all the actions taken by the state of Oklahoma during allotment were clear violations of this act of Congress. We can also see there was a crucial failure in the office of the President of the United States to fulfill its duty to enforce this particular law. Second, as Title 25, Section 71 so clearly states, no obligation of any treaty shall be hereby invalidated or impaired. While the treaties of 1833 and Neosho promised these lands would, quote, forever belong to the Cherokee people without state interference, then the possession of these lands by any party other than the Cherokee would constitute obligations which are no longer being met, hence the current violation of Title 71, Section 71. This would especially be true of state possession, as the state was expressly forbidden by Congress in treaty, the so-called supreme law of the land. Additionally, the Treaty of Neosho promised the Cherokee people would have the right to establish their own form of government, consistent with the values and beliefs and cultural identity of the Cherokee, which, as the CNO and UKB were modeled after the federal government system, remains yet another unfulfilled obligation. Third, it is also an apparent fact that at no point in history has either the state of Oklahoma or its municipalities been granted jurisdiction over the Cherokee people or tribal lands by Congress, nor did the state choose to claim those rights when the opportunity was presented in 1953 or any time since. It is also clear that in recent years the courts have agreed to this fact, at least in regards to criminal law. However, I submit that this notion that our nation's borders are to only be recognized with the timing and occurrence of criminal activity, as it is suggested in McGirt, Hogner, and Hooper, is not only ludicrous, it's an insult to the Cherokee and a reminder of the broken promises to our people. Worse yet, it is insulting to the memories of more than 4,000 Cherokee ancestors who died during our forced relocation to these lands. These Cherokee ancestors, many of whom were among the young or elderly, but all of whom died believing the false promises made by the United States that these lands would belong to our people forever, with the freedom to govern them as we so choose, were true. Now, it is obvious that the intended outcome to these proceedings is a free and independent nation for the Cherokee people, so one can expect that there are those who may feel that Congress expressly forbid the recognition of tribes as such with Title 25, Section 71, which states no Indian nation or tribe within the territory of the United States shall be acknowledged or recognized as an independent nation, tribe, or power with whom the United States may contract by treaty. I concede that Congress may have written Section 71 with the intent to remove tribal rights to independent sovereignty. The reality is that is not what was accomplished. If Congress had wished to terminate tribal rights to independence, then the law easily could have and should have been written to state, no Indian nation or tribe within the territory of the United States shall be acknowledged or recognized as an independent nation, tribe, or power. If Congress had written this and nothing more, then tribal rights to independence would have been undeniably terminated. However, the intents of Congress are clearly demonstrated when they limit the scope of Section 71 by further stating with whom the United States may contract by treaty. This simple addition to the previous statement completely alters the meaning of the entire phrase, and Congress merely terminated its rights to create treaties with the tribes as independent sovereigns. When you consider what the U.S. Supreme Court stated in McGirt, wishes don't make for laws, then the wishes and intents of Congress with Section 71 become irrelevant against such clear and unambiguous language. This harm against the Cherokee people has not only robbed our nation of its freedom and independence, but of valuable tax and natural resources as well. This has forced multiple generations of Cherokee families to live in relative poverty for over a century. This additional financial oppression gives a valid argument for punitive damages, which are not being sought at this time. This makes the current relief requested seem to be, in retrospect, a rather generously forgiving sum. In regards to the United States versus Lexington Mill Company, as the Supreme Court stated in the simplest possible terms, if Congress has written a law that is within their power to enact, then if the language of that law is clear and concise, as it is in the treaties and statutes of the plaintiff's claims, then the court's role is no longer to mediate, but simply to enforce the acts of Congress. This direction by the U.S. Supreme Court would obligate this court and compel the conclusion of these proceedings in favor of the Cherokee people and their requested relief. This would further mean that, given the clear language of these acts of Congress, any attempts by the state to prevent or delay the enforcement of federal law could potentially result in further penalties and fines under the Supremacy Clause of the Constitution. In light of these blatantly criminal actions taken by the state of Oklahoma to not only violate federal treaties and statutes, but to also oppress the people of a foreign and independent nation without cause for over a century, the plaintiff hereby moves this court to grant declaratory judgment in favor of the Cherokee people and issue the necessary injunctions and orders to fulfill the requested relief. The plaintiffs respectfully request that, in consideration of this prolonged harm against a peaceful people, that the court expedite all actions leading to the complete restoration of rights to the Cherokee tribal lands in Oklahoma, acknowledgement of the Cherokee people in Oklahoma as a free and independent nation, and $50 billion in compensation for the Cherokee citizens of the EBCI, CNO, and UKB, to be distributed in such a manner that all citizens will be raised to an annual income of no less than 300% above the poverty line. The remainder to be held expressly for usage by the newly formed and unified government of the Cherokee people following the dissolution of the EBCI, CNO, and UKB. The plaintiff thanks the court for its time and service in this matter. Go to change.org/Cherokee_freedom to support this case, which has now been sent to the 10th Circuit.